Hello, everyone. Welcome to the third session of the Global AO Action Anniversary or the Global AO Festival that we are calling it. This is the European session, which is the legal landscape post the advisory ICJ advisory opinion, which will focus on litigation policy and corporate accountability. We are joined with a very esteemed panel today, jam-packed panel. But before that, I just want to go back a little bit and top it off with saying that today is 1 year from the ICJ advisory opinion that we've got last year. And we want to, we are a long way into implementing what the advisory opinion would look like. We've had a successful UNGA resolution adoption earlier this year, and through that, we are also going to look at what it means from an implementation of the advisory opinion stage, and what it specifically in this webinar, what it specifically means in litigation, what it specifically means for conduct of corporates and third-party actors and non-state actors, and also what advancement has happened in the legal realm, not just since the ICJ advisory opinion, but also the conjunction that it has with so many cases happening in so many countries, with the Inter-American Accord advisory opinion, with the ITLOS advisory opinion, also the incoming African AO advisory opinion. Now, the reason again for focusing on corporate accountability litigation policy in Europe is that we have seen a lot of cases before and after the AOs, and Europe is a host for major countries that are big polluters and also historical polluters. So keeping that in lens, I will not take up too much time, and I will just let everyone know what it's going to look like today. So the format is going to be a rapid fire talk show kind of a situation where I will be asking questions, and everyone gets around 2 minutes, 3 minutes to respond to those questions, and then we have some time in the end to have an open discussion to answer questions from the audience, but also if otherwise, keep it a free-flowing discussion as well. So having said that, I will move on to the introduction of the esteemed panel that we have today. Firstly, we have Kate Cook, who is the barrister from Matrix Chambers. Then we have Danilo Garrido, who's the legal counsel of Greenpeace International and has been a long-standing supporter of the advisory opinion, also a very close colleague. Then we have lawyers from Notre Ferratou and Stevenion, and also the legal advisor of Melu Defensi, Catherine Vanes. And moving on, we also have Francesca Masha Klein, who's the legal advisor at German Watch. Again, a very most of these organizations have been at the forefront of climate litigation, along with Camilla Polera from CIEL, the Center for International and Environmental Law. We have Johannes Vanland, who's a legal advisor at HEX. And then I am going to be your moderator today. My name is Aditi, and I am the lead of strategic litigation for World's Youth for Climate Justice. Having said that, I think I'm going to directly move on into the questions so that we have enough time in the end. So my first question, I think I'm going to give to Kate in the context of adaptation cases. So currently, what is your read on the European climate litigation landscape post the advisory opinion, and especially in light of relevant domestic and regional standards? What could be one of the most promising openings in the legal community that one could keep an eye on.
Thank you.
Kate, you have the floor.
Thank you very much. And it's great to be here on such an amazing panel as well. So I will focus on adaptation, but I'll also bear in mind the topic of corporate accountability and accountability of private actors, because I think it's tempting when you think about adaptation to think about state responsibilities, which are critical, but there's obviously a close back and forth between private actors and states in this area. Firstly, on the ICJ opinion, one of its great strengths, a unanimous opinion, is that it provides a framework that extends beyond the legal regimes that the court directly addressed or was asked to address in the question referred to it, because the general duties it looked at, prevention of damage to the climate system, cooperation, relying on precaution, and so on, extend much more widely, as do the customary duties it referred to. And some of the individual judges talk about trade and investment and so on. So I think all regimes are wide open unless proven otherwise. It's hard to imagine a regime that is relevant to climate change that isn't affected by the opinion. And coming back to adaptation in that light, I think there are two things I wanted to focus on. One is coming back to, as we always do, the best available science, the fact that it is dynamic and it is continuing to evolve. And I think that is critical because two of the things that have become clearer and clearer is that real world impacts of climate change are accelerating faster than predicted in IPCC assessment reports. That's not necessarily to criticize the IPCC. There are probably a range of reasons for that, but that is clearly what is happening. And it would be interesting to see how the seventh assessment report deals with that. The other key element is that there is an increasing focus on tipping points, on the crossing of boundaries that lead to irreversible harm, whether it's collapsing ice sheets, the savannaization of the Amazon, the redirection of the AMOC. You know, this is another whole topic in itself. But thinking about adaptation, I think, and also bearing in mind always the relevance of human rights law, I myself am involved in a case that's ongoing on adaptation and human rights, which I can say a little bit about, not too much as it's an ongoing case. But putting those strands together, I think for states, they clearly need to take into account in a forensic way the risks that are actually being faced by people and ecosystems in real time. And one of the problems we found in the UK is, first of all, a general neglect of adaptation. Our own UK Climate Change Committee described it as the Cinderella of climate change policy. They said it was still sitting in rags by the stove, under-resourced, underfunded, and often ignored. So that's kind of where our own expert body saw it, at least a couple of years ago. But I think for courts, they will have to look in more forensic detail at the compliance by states and potentially by private actors as well with their human rights obligations. It's not enough to have a generic aspiration to deal with flooding or extreme heat or whatever. You have to apply a scientific approach where you look at the evidence on specific issues, whether it's workers' rights, inside or outside. What are the levels of extreme heat? How many days of wet bulb temperature are there going to be? What are the health impacts on workers? What are the impacts of climate change on the environment that have implications for human safety? I run a podcast series called The Common Concern, so I'll just plug that. But we recently did an episode on Wales, the country Wales. And one of the issues there, one of many issues, is the post-industrial landscape. There are disused coal tips that have become more unstable because of increased rainfall due to climate change. And there is a tragic history associated with that in Wales, which you can hear about on the podcast, which is very important. So there are everywhere you look, every place you look, every issue you pick up, there is an adaptation issue. And it needs an urgency that I think is lacking. And for the private sector, this is relevant to where you build, how you build, the people you employ, the land that you are proposing to use. That's the environment within which you're operating. So if the state does not have sufficiently effective goals and objectives, I think private actors need to think carefully about the way they invest in their own activities. Because as we know, the ICJ did not address the temporal aspect of responsibility for states. In other words, who knew what and when in terms of the risk of climate change. But I think the same issue arises with private actors, because you need to look at every stage at what they know, what financial actors know in terms of where they're investing money. We talk a lot about fossil fuels, quite rightly, but we also need to look at other investments and the way in which they are addressing or not addressing the risks to people and ecosystems. Frameworks like the Sendai framework and the ICJ's own jurisprudence and human rights law all converge on some key elements, which is basically stringent due diligence, proactive and vigilant approaches to risk. And that applies to adaptation. And I don't think yet that we're seeing the kind of urgency and attention to detail that we need. One of the proposals or one of the framings that's relevant to the case I'm working on is the use of smart objectives for adaptation that are specific, measurable, achievable, realistic, and time-bound. In other words, SMART. It doesn't really matter what acronym you use, as long as substantively your adaptation action is meeting those sorts of requirements. So I don't want to take up more time because I want to hear from everyone else, but those are some of the issues that I think are really important. Clearly, human rights is central to this, and my own view is that the pushback against human rights in many countries, including in Europe, can be countered when you explain to people that human rights law is there to protect everyone from these real world impacts that are affecting everybody's health or workplace or home, and will continue to do so. And that is an area of human rights law that is evolving quite rapidly and is relevant to everyone. It is not a sort of niche thing that can be pushed back by politicians. It is about people's rights and the duties of private actors and states to take those seriously and to be held accountable when they don't deliver sufficiently effective protection. And I'm happy to stop there.
Yes, thank you so much, Kate, and also for summing it up with the human rights aspect, because I was that was a good segue to go on to the next question to Danilo, especially given the landmark case on adaptation and equity, and also the approach of not leaving people behind, the decolonial approach in climate action that we've seen in the Bonaire case. So, having said that, Danilo, how has the AO influenced the decision in the Bonaire case? Because it was ongoing earlier, as we understand it, right? And how would you see this outcome influencing other domestic courts and challenging the conversations on states' legal duties to provide an adaptation in an equity-based manner? And if I must also, to not put you on the spot, but also looking at it from a point of view of overseas territories, I think that's a very interesting approach as well to look, because there are so many, especially based in the global south, and the way they are connected to their host countries. So yeah, please, the floor is yours.
Perfect. Thank you very much, Aditi, for the warm introduction and for the slight curveball at the end of that question. So yeah, looking forward to thinking about it while I give my my thoughts. Well, so I think the Bonaire case is really interesting because the hearing was shortly after the ICJAO was rendered. It was in November of last year. So there was the opportunity for the legal team, which I was not a part of. It was mostly all my other colleagues from Greenpeace Netherlands that were working on this case. But they did include, even though only at the oral stage, some arguments and some references to the ICJAO. including the argument that 1.5 was legal threshold under the Paris Agreement, that the CBDR principle applied in this case, and that it also required the Netherlands to take into account its historic emissions when creating its climate policies, bearing in mind the specific and particular impacts and disproportionate impacts that it has on the citizens of Bonaire, which is in overseas territories in the Caribbean, as you mentioned, Aditi. And what was really interesting to see was also that the court took some of those arguments on board. So the Dutch court, citing the ICJAO, it confirmed that the Paris Agreement and other international instruments were important to determining the obligations of the Netherlands domestically. So it was a second rebuffal of the arguments that we saw a lot in the ICJ proceedings of especially developed states trying to limit all of the international obligations regarding climate change to just Paris. And what was good to see both in the ICJO and in this decision on the Dutch court was that this argument is not seeing the light of day in the judicial decisions coming out post the ICJAO. And I think what is really key to point out is what happened next. So not only in terms of other courts, but also in terms of this proceeding, because the Netherlands is appealing this case. And in the meantime, it must comply with it. And it has put climate adaptation strategy to consultation, which closed just a couple of days ago. But it is appealing. And in this appeal, we are surely going to see the ICJO even more cited, both by the plaintiffs, and that I can guarantee, but perhaps also from the other side, and trying to limit the importance of the ICJO in this case. And I think on a final point on this, I think that this decision also provides reassurance and guidance for other courts when faced with cases against governments. Because we know, especially in novel areas of the law, sometimes judges look at the comparative practice at what other courts are deciding, and this is a very good precedent, and we hope that it will impact how other courts are deciding adaptation, mitigation cases, and also how it is incorporating the ICJO in their legal reasoning in domestic cases.
Yeah, thank you so much, Danilo. It very essentially is, and in terms of regulations, when you talk about state regulation, I think the interesting part about the ICJ is that there is a specific section in the entire which then talks about how states then also should regulate private actors within their jurisdiction. So I think that also, this case especially gives it that precedent along with a lot of other cases, especially transnational cases that are ongoing and happening, that we are going to discuss with Johannes and Francesca. Again, so moving on from the state obligation to regulate its own activities, but also the state's obligation to regulate corporate actors. And I do see that litigators are using basis of a lot of arguments that are coming out of the AO to in framework cases, especially like the due diligence specifications that the ICJ talks about. So, and also what needs to go into what are the standards of due diligence when you're talking or looking at corporate actors in that jurisdiction. So moving on from a little bit of the state responsibility to Anne, I would like to ask you, given the AO's implications on corporate accountability and the way it has sought out, especially in a paragraph around that it talks about fossil fuel, and then a few paragraphs before and after that, and talking about historical emission as well. I wanted to ask what, particularly regarding states' due diligence obligations and the legal conclusions relevant in litigation directly against corporations, we would welcome your reflections and drawing on your experience on fair share cases against France and then also the recent climate vigilance victory against Total as well. So you have the floor.
Thank you very much. Yes, absolutely. I think that 1 year after the ICJ advisory opinion, we are already seeing one of its most practical effects. It's not confined to litigation against states. It's beginning to shape corporate climate litigation, and we have a very recent example in France. So we at Notre Affaire à tous recently obtained a landmark judgment against Total Energy under the French duty of vigilance law. It was delivered on the 25th of June. The court expressly relied on the ICJ advisory opinion alongside the European Court of Human Rights claims hearing and judgment to hold that climate change is a serious present and future threat to the enjoyment of human rights. So it was really a new decision on that, like the CIEL case. And on that basis, it established a clear link between climate change and human rights and held that companies must identify and prevent climate-related human rights risks in their vigilance plans. And it confirmed an interpretation of the French duty of vigilance law that is highly relevant for the future implementation of the Corporate Sustainability Directive, CSDD. And so this is a very significant development, and the ICJ advisory opinion is no longer simply an international law authority addressed to states. It is used by domestic courts to interpret corporate legal obligation, and it is likely to influence the interpretation of the CSDD as it is going to be transposed across Europe in the few months to come. So at the same time, I want to say a few words of our fair share case against France. It was launched last year, and we relied directly on the advisory opinion to argue that France must do its fair share of the global efforts, taking into account its historical responsibility and its capacity to act. So the opinion confirmed that these are legal obligations and not merely political aspirations. So yeah, so for me, it's the real legacy of the advisory opinion. It's creating a coherent legal framework in which state responsibility and corporate accountability reinforce each other. And states have a duty to regulate, companies have a duty to prevent climate harm, and courts are increasingly connecting the two. So at least I'm hopeful. Thank you.
Yeah, it's so important. Like as you said, like it's not optional anymore. State obligation and also corporate accountability. But at the same time, I think it's very interesting talking about fair shares, talking about like historical emissions, talking about how looking into case by case basis of how it can be calculated. I think it's so important to follow money when it comes to tackling this crisis, right? And then we see the influx of financial institutions like private equities, investment banks, etc. And I think, I mean, we have Catherine here who is very well into the sector and this kind of litigation. So I'm not going to say much, but I'm going to give it to her to talk about, or just to just elaborate a little bit on why also the AO actually offers an important support to that kind of strategic litigation, especially against major financial institutions, and also your experience on drawing on Milieu d'Fensi's work in the area. And also, interestingly, whether it has actually been challenging to use the AO arguments, especially if it's a state-focused case in the context of private actors, or if it's easier if like financial institutions in itself are state-owned. So, Catherine, you have the floor.
Thank you, Aditi, and thank you for having me. So yes, I'm working in the climate litigation team at Milieu d'Fensi, amongst others, working on our case against ING Bank. And I think to start with, it's important to mention that there's already a growing consensus that private actors such as multinationals, but also major financial institutions have indeed a responsibility to do their part in seizing climate destructive conduct. So, for example, the UN Working Group on Business and Human Rights recently concluded that financial institutions supporting Saudi Aramco's expansion might be violating international human rights norms and standards. And our climate case against Shell also confirmed the existence of a climate mitigation duty for private actors. And the ICJAO advisory opinion only strengthens our legal argumentation in these cases against private actors, because domestic courts rely on international law as an objective point of reference to interpret the duty of care in these tort law cases against private actors, such as our case against ING Bank. So some important conclusions from the ICJ advisory opinion that strengthen our legal argumentation are, well, first of all, the recognition of the 1.5 degree goal as the primary agreed temperature goal under the Paris Agreement. This is very fundamental. And of course, the recognition that climate change is a highly urgent threat leading to infringements of human rights, and that people must be offered protection against it. It confirms, of course, that states, but also non-state actors have a responsibility to act. And it recognizes fundamental legal principles, which were already touched upon, such as the CBDR principle, but also the precautionary principle and the principle of intergenerational justice. And these also play a major role in our Supreme Court appeal case against Shell. But most fundamental, quite fundamental to our case against ING Bank is, of course, also the recognition that financing climate destructive conduct should be ceased. So, of course, indeed, Aditi, the ICJ primarily addressed public financing, but this gives nonetheless an important reference point for national courts to determine the obligations of the private financial sector to cease financing fossil fuel. And this very much helps our argumentation in our case against ING Bank, because one of our demands is that ING Bank has to cease financing new fossil fuel. So I guess in conclusion, the advisory opinion provides some very important objective reference points to establish the international law norms that are applicable in our cases. And they inform the courts to determine the duty of care of both ING Bank, but also of Shell.
Yeah, thank you. Yeah, thank you so much. Also, like when you were talking, I was then, thinking about how it's all connected in terms of how subsidiary companies operate in different jurisdictions, and how then that can get connected, especially if domestic courts invoke these basic obligations, drawing from international law, but not just international law, also like the precedent that cases like these set for other courts, as most of you have mentioned right now. So going into that a little bit and like talking about evoking accountability for damage that has been done in the matter of loss and damage, in the matter of fairness, I would then like to ask Masha, with your experience in the RWE case, it did confirm the principle of corporate accountability on climate harm, especially given that it was a transnational corporate accountability litigation case, and that kind of litigation is now growing in the context of loss and damage. So what is your overarching opinion or read or understanding of the European loss and damage litigation landscape, especially post the advisory opinion, also considering what Kate earlier spoke about when it comes to state responsibility and what the AO said about state responsibility? So, Masha, if you can touch upon that, the floor is yours.
Thank you so much for having me and for that thoughtful, interesting question. Yeah, so I think, 2020 2025 was really a significant year because not only the AOs, but also the fundamental decisions we saw in the field of corporate climate liability. So just 2 months before the AO, the Higher Regional Court in Hamm made its final decision in the UEA versus RWE case, and end of the year we saw a decision or somewhat preliminary decision in the Halsem case, which I think we'll be speaking about later. And what the court really did was to clear some significant legal hurdles when it comes to corporate accountability. So just to name a few aspects that it went into, it said that it is in principle possible to establish causation between the emissions of a corporation and a damage or an impairment suffered in another part of the world, and as part of climate-induced consequences, if the emissions of that corporation can be considered significant, which the court said is the case if these emissions amount to those of industrial states. And the court, for example, also stressed that the consequences of fossil business models were foreseeable from the year 1965 onward. And we're seeing that this reasoning is incredibly useful for other cases. I just mentioned the Holcim case, but we're also seeing it used in the case of Belgian farmers against Total. And there's a new case in Germany as well by Pakistani plaintiffs demanding damages from RWE. So there's a lot happening in the field of corporate climate liability in the European context. And I think the next step is really for us to do three things, which is protection, advancement, and implementation. Protection means that we really need to protect and secure and also defend the legal wins we've had so far because yeah, we're seeing legislative attempts in New Zealand, in the US, but now also in Germany to actually exclude corporate liability. And I think it's really important for us to stay part of that discourse and also exchange on strategies on how we deal with that type of backlash. Then in terms of advancement, we still have a way to go when it comes to actually making a polluter pay. And that needs to happen, I think, for these types of cases to fully unfold and to fully have the impact they need to have. So, for one, in terms of legal theory, we need to develop and test concepts of fault, what constitutes wrongful emissions. That will also be very relevant for example, the damages case of Pakistani plaintiffs against RWE. And on the evidentiary front, we're dealing with a challenge of integrating the findings of attribution science into the legal procedure as such. And I think that's also, a field that needs to be tested and explored in court. But we're seeing that attribution science is progressing, so becoming more and more suitable for these types of claims. So I think the prospects are good there. And then in terms of implementation, so as you mentioned, the ICJAO requires states to not only reduce emissions, but actually also make sure emissions are reduced that stem from private entities. Plus, they have a duty to cooperate, and that also encompasses financing and loss and damage. So, given that, as well as the developments in the field of corporate climate litigation, there is a financial risk for states and there is a financial risk for companies. And all of this points to the fact that states need to find a overarching mechanism to actually include corporations when it comes to the costs of climate change. And we saw with the massive heat wave in the EU that suddenly the European Greens were, for example, proposing to make the top 5 polluters pay to make the EU heat proof. So I think there is some momentum there. And we've also heard that there's some openness towards including corporate entities when it comes to the costs of climate change within the German government. So I think we really need to seize those opportunities and also find an overarching mechanism to make sure that polluters are included when it comes to the costs of the climate crisis, which is not only adaptation, but also loss and damage.
Thank you. Thank you so much, Francesca. Yeah, it's quite interesting talking about how it's connected not only through the conduct of state, but also like looking at tipping points, looking at, something that Anne also mentioned and also Kate mentioned earlier, looking at tipping points and seeing how those can be those can be held not only through state conduct, but also through regulation. And then also looking at liability and how it then forms, especially when it comes to claiming damages for harm that's already being done. And then there is also the polluters pay, and also declarations of individual judges that go more directly into how Scope 3 emissions can be dealt with, what attribution can do, and how it can be then framed on a case-by-case basis. Thank you so much for that exhaustive understanding through examples. And then just talking about compensation and damages, I think it would be also interesting to look at the Holcim case that Johannes has been in the thick of. So Johannes, directly to you, is that my question would be then, can the AO support arguments in loss and damage cases brought by the Pari Islanders, especially in this particular case, and then also at lower court levels and more broadly speaking in a more public facing framing? Like, what do you think?
Yes. Thank you so much, Aditi, and also to the other organizers. It's great to be here. Yes, I think the ICJ advisory opinion can be very helpful for the Pari Islanders in their lawsuit against Holcim. And I think it can be helpful both inside the courtroom, but also outside of the courtroom, which is also very important. So the Pari case, of course, is one of these transnational cases that you mentioned in the beginning. The Pari Islanders don't live on a Pacific island, but what they see on their island in Indonesia is, I think, very common to many of the small islands in the world. And that is why they are suing Holcim for mitigation measures, but also adaptation and loss and damage support. And so if we look strictly at the legal side, the complaint by the Pari Islanders is, of course, based on Swiss tort law, and it's directed against a private company. So it seems to be quite far removed from what the ICJ addressed, which is the responsibility of states. However, I think this is not the full story, because under the Swiss constitution, there's an explicit provision that requires national courts to interpret national Swiss law in line with fundamental human rights guarantees. And this is also very relevant for the Pari Islanders, who rely in large part on their personality rights, which is a very broad clause under Swiss law, so very open to interpretation in line with human rights guarantees. And we have seen this very clearly in the first decision made by the Cantonal Court, which is the first instance court. In December last year, as Masha mentioned, the court decided to admit the complaint, and they didn't decide on substantive questions yet, but they still stated very clearly that in climate litigation, it could be possible to have indirect horizontal application of human rights guarantees under Swiss law. So, of course, human rights guarantees in general bind the states, but the court said, yes, we think it's very conceivable to have a indirect application here also against a company such as Holcim. And if we take that seriously, then the ICJ's extensive findings on everything about the climate change impact on human rights will also be very relevant on how the Swiss courts interpret Swiss tort law and will decide the Pari case. And as far as I know, there are similar principles in other jurisdictions. So I think the ICJ opinion, even though it's at the level of states, will be very relevant also for national decisions against private companies. So this is, I think, one of the most important points inside the courtroom, but I think outside of the courtroom is also very important. And Danilo already mentioned that, the ICJ gives guidance to other national courts around the world, but I think it's even goes beyond judicial guidance, because we have seen in the past, unfortunately, quite serious attacks on courts that were tasked with deciding climate litigation. And even here in Switzerland, we have seen it very clearly. After the landmark decision by the European Court of Human Rights in Klimasenioren versus Switzerland, the discussion here was really dominated by voices that said, this is judicial overreach. There are these foreign activist judges in Strasbourg, and Switzerland should just leave the European Convention on Human Rights. So unfortunately, there's a very strong backlash from certain quarters. And also in the Holcim case, after that positive decision by the cantonal court in December, parts of the right-wing media have accused the court of undermining the democratic process. And so we see there are like certain groups that have a very strong interest in trying to defend against these cases, even with measures that are not legitimate. And I think the fact that we now have the highest court in the world deciding this case and saying very clearly and unanimously that climate change is a legal question and there can be legal accountability for the consequences of climate change, it not only stops the dilution of responsibility when it comes to climate change, but it also gives much needed backing to courts around the world to actually do their job, assume their responsibility, and decide these cases. So I think ultimately the ICJ advisory opinion, it's a big win for climate justice, but it's also a big win for the rule of law.
Yes, thank you so much, Johannes. I think that is, putting it into context, like, talking about what's happening in court, what the courts are deciding on merit or on admissibility and otherwise, but then bringing it back into the real world and putting it into context of what is happening in reality in the political landscape is so important, because no matter how good the decision could be, if it doesn't fit into the if it's not digested by the political context of the region or the country, then it just becomes the implementation of it then, is another challenge, as you were mentioning. So I think, like, especially from a human rights point of view, I think it is also quite interesting to see this because of the right to a healthy environment resolution that we have seen recently. And having said that, I mean, I don't want to talk too much about it because we have Camilla in the room. But I think just taking from what Johannes said, but taking this outside the court, looking at the narrative, what it means outside the court, I think my question to you, Kami, would be then, when the ICJ has clarified that right to a healthy environment is a human right, and it has put it into context of all the laws that are applicable in the entire regime of international law and human rights law, what implications might this have in relation to generally the right to human rights, right to a healthy environment campaign at the Council of Europe level, and then at the European level in general as well?
Thank you very much, Aditi. And first of all, it's truly an honor to be here celebrating this anniversary with you all. So a year ago, the ICJ confirmed that states have binding obligations to respect, protect, and fulfill human rights. And that this includes the right to a healthy environment, both in its own right and as a prerequisite for the enjoyment of all other human rights. In doing so, it acknowledged the culmination of decades of legal developments at national, regional, and international levels. As many of you know, the right to health environment has been recognized by the Human Rights Council in 2021, by the UN General Assembly in 2022. More than 100 countries' constitutions worldwide recognize this right, and all regional human rights systems, except for one, the European one. That's how the ICJ landmark opinion plays a role. At a time when the ICJAO movement looks at its implementation, what this victory that means for Europe is clear. The Council of Europe has a unique role in safeguarding human rights, democracy, and the rule of law across Europe. While the European Court of Human Rights has progressively interpreted that the European Convention of Human Rights to protect individuals from environmental harm, it remains the only regional human rights system that has not yet explicitly protected the right to a healthy environment, even though most of its member states have already recognized the right in their constitutions or domestic legislation. And after the ICJ advisory opinion, maintaining this kind of gap has become impossible to justify. And the momentum is already there. The campaign for the right to a healthy environment in Europe brings together more than 500 civil society organizations, children and youth organizations, academics, and allies from intergovernmental organizations to advocate for a strong, legally binding instrument protecting the right to a healthy environment at the Council of Europe. The head of state and government of the Council of Europe's member states already committed in 2023 to build on the political recognition of the right to a healthy environment. And last year, the Committee of Ministers instructed its deputies to move forward as quickly as possible in their consideration for a possible binding or no binding instrument in this field. And then more recently, the Council of Europe Commissioner for Human Rights stressed the urgent need for the adoption of a legally binding instrument to protect the right to healthy environment. We're here today celebrating the anniversary of an incredible victory, one that reminds us of what a movement can achieve together. And the impact of that victory and the power behind it should really inspire and propel future successes. So on behalf of the campaign for the right to healthy environment in Europe, I call on each and every one of you to join us, to rally with us, and to think creatively with us about how we can leave member states with no choice but to act. Because the time for states to ignore this reality is over, and all the 46 member states of the Council of Europe have run out of excuses at this point. So the time to act is really now. Thank you.
Yeah, thank you so much, Kami, for bringing it all together and putting it in context. I think it's also quite interesting if you look at if you look at the declarations and also the separate opinions, there are judges who have gone a lot further from the unanimous opinion that they've given, right? And I think that's quite significant. Like, legally speaking, there is a lot of academic and literary discussion that we can do of what can be taken, what can be applied in that sense. But I think from a point of view of consciousness of how this crisis needs to be tackled, dealt with, litigated, and then brought back into the legislative political context, I think is really interesting. And with so many, I mean, I know there are so many other cases that have come up, and I would like to give a few special mentions to the cases that have been filed and have used the AOs, not just the ICJAO, but also the Inter-American Court's advisory opinion, the Porto Alegre case in Brazil, the Odette case in England. Then there is I think there's there's a whole time case that we mentioned. There's the Australian Securities and Investment Commission, the Mercer case, that the Mercer case that has been bought under greenwashing claims, etc. So I think there is like a plethora of cases that we are seeing in all these jurisdictions that will be taking in the jurisprudence that's coming out of these AOs. And having said that, it is so important to look at all the aspects that were highlighted today, from issues of how admissibility of transnational cases, how domestic courts look at it, looking at the human rights aspect of it, looking at accountability from a point of view of not just state obligations, but how states should regulate actors and also corporate actors themselves being the standard of mitigation and standard of adaptation that they need to follow as well in such cases, and how it can be litigated as well. And having said that, I think I don't want to take up too much time because we only have 10 more minutes, and I think we have a question in the box. So I'm just going to leave my thoughts there and read out the question to any of the panelists. So please feel free to either write your answer or to talk about it. Alan is asking, or Alan mentions, that the ICJ advisory opinion affirm general obligations of states to set NDCs to levels that can keep global temperature increase under 1.5 degrees Celsius, and to cooperate to implement this. But this does not address NDCs of specific countries, such as large greenhouse gas emitters could continue setting NDCs that are too high. Might it be useful for a group of most impacted countries to launch a class action contentious case in the ICJ against some of the large emitters, those who accept the ICJ jurisdiction, in order to drive down the NDCs to ensure that they are sufficiently low to keep under 1.5 degrees Celsius? I think that's a very interesting question. So I'm going to open the floor for anyone who would like to take it. Danilo.
Yeah, I can start, but I also know there are people with more extensive experience at the ICJ than I do. So my 2 cents about it. I think it's important to also to bear in mind what the ICJ is going through now. So there are a lot of cases they are not class action cases, but they have been sort of mass adhesion cases. So they are traditional contentious one versus one cases, but in the genocide in Gaza case, for instance, there have been a lot of interventions. So perhaps thinking of a case that could allow for that intervention, even from countries that perhaps do not regularly accept the jurisdiction of the court for all matters, I think that could be interesting. But the main issue still remains on how to get jurisdiction, even for a simple, contentious, traditional case for climate change. There are routes being discussed. There's also the element of surprise that should not be understated. So, but I do think that it would be very good to see something contentious arising from the ICJ, and I do think there are possibilities going forward.
Thank you so much, Danilo. Kate, please go ahead.
Thank you. And just to say, I mean, I think it's important when you're considering the gaps in action, like underachievement of NDCs, why that is. What are the obstacles to states committing or taking ambitious enough action? And I think, so I just wanted to slightly shift gear to say, it's important also to look at structural issues. And I think law domestically and internationally needs to start doing that. So as someone said earlier, I think it might have been you, we need to follow the money. And I think we need greater attention on areas of finance flows that are at the moment unaccountable. So, as has been said, states have a duty to regulate private actors. That includes financial institutions, and that includes those that currently act under a sort of relatively opaque cloak, such as private equity and asset managers. There's been attention on banks, which is absolutely right. But there are financial actors who control huge volumes of money that is going into fossil fuels, for example, and agribusiness, with huge climate implications that are relatively unaccountable. So I think in thinking how to challenge states' NDCs, it's important also to look at those structural issues. And the other thing I just wanted to flag, I know we've got very little time left, is I think geoengineering is a huge issue that is going to emerge, because that will be a lot of this we know doesn't add up. What the AO has said makes sense. It is based on established principles, and what is happening on the ground doesn't meet that coherent framework. So states are likely to start trying to say that geoengineering is the way through this. And, you know, there are a whole host of issues around that. But I think we need to apply the same kinds of human rights standards. So just to bring it back to the actual question, in thinking about challenging at the ICJ, I think there is a layer of thought about the systemic issues that are confronting us and how to attack those on all levels, domestic, regulatory, as well as international, principally in relation to finance flows, because that's what drives all these engines, and the profit motive is what drives all these industries. So there are a host of ways of addressing that. Thank you.
Yes, thank you so much for such an exhaustive response, Danilo and Kate. I hope that answers your question, Alan, and much more. There are two more questions. So I think there is, we have some time left. So I'm going to go to the second question, which again, I think is open for all the panelists, is Europe has seen such intense heat waves. So do we see more specific adaptation focus cases coming forward, relying on the AO, and what might this look like? I request anyone to please keep it brief, because there's one more question which I think is an interesting one that we should answer. Kate, please.
Sorry,
go ahead.
very briefly, I'm only going to mention the case that I'm working on because it does relate to adaptation. I don't want to say too much about it, but Friends of the Earth and two British individuals are challenging the UK's National Adaptation Plan at Strasbourg. We're at the early stages of that case going through. One of the issues is extreme heat, and one of the individuals is someone with health vulnerabilities who lives in an existing, in a care home, obviously very affected by extreme heat. And one of the issues around the National Adaptation Plan, for example, is that the requirement to have proper air conditioning and so on only applies to new build homes. And obviously, most people are in existing homes. So that is just one example, but I'm sure there will be many, many, many more, including those affecting workers' rights, which I think is a huge area that we'll see more action on. Thank you.
Yeah, I think just to add to that on the heat waves, I mean, if you look at the South Asian jurisdiction and also parts of Southeast Asia, which we were discussing earlier as well, there are a plethora of cases that are coming in. They're not specifically categorized as direct climate litigation as we know it in, let's say, in the Western world, in Europe and Northern America, but they come from an environmental perspective, but they do definitely look at aspects of adaptations because of the heat waves, and also the infrastructure that needs to be changed in going forward to adapt to these very slow onset climatic conditions. So I would then request you to look at those cases as well, especially in terms of adaptation cases. There is a last question. We have like a minute or two to go. And I'm gonna, again, I think that's for all panelists again. This person is currently writing a paper about the ICJAO and implementation of the ICJAO, they ask, how do you think in concreto assessments should be conducted, since it requires a great combination of legal, scientific, temporal, and other sorts of information? Which institution is prepared better, if any, to attribute responsibility to state or a group of states, mostly at the international level? And then the second part of the question is the ICJ itself, or would we need, whether it's the ICJ itself, or would we need a new tribunal or mechanism to process these claims? It's a heavy-handed question. If anyone would like to address that, and then we can wrap it up. Also, because it's a long, thought-out question, I also do not mind for whoever's written that question. Please feel free to email it to us, and then we can forward it to the panelists on email, and then they can get back to you on that as well. Danilo.
Yeah, just very, very briefly. I think, it's important to think about, judicial implementation and monitoring, but I think a great avenue for also the implementation of the ICJAO are the political avenues. So I think the ICJAO, it really helps shift the narrative and start talking about, the responsibility, and to really, coordinate global South countries, and really create a movement to ask in political forums for reparations, and for active monitoring. I think that could be something useful to dedicate our energies to.
Thank you so much. I hope that answers your question. And having said that, I think we are 2 minutes over time, so I'm gonna wrap this up. Thank you so much, everybody, and Camilla, Catherine, Danilo, Masha, Johannes, Kate. Thank you so much for joining and also giving your time. For this, we just for everyone who is in the webinar right now, we also have 2 more sessions coming up. The Caribbean one, where we are going to look at the AO from a Caribbean perspective, and also then finally the Latin American session later in the day. Thank you so much again. And another thing that I would like to mention that I'd forgotten earlier is that now we have the implementation tracker live on WICJ's website. It is very dearly made by Nicole Ponce herself. A lot of efforts have gone into that, and I hope that participants take a look at that. I think it would have a lot of FAQs that can be solved in terms of implementing, and just take this discussion that we had today a little more further in terms of avenues from a judicial but quasi-judicial but also political perspective. Thank you so much for joining. Thank you so much again, and I will let everyone go now.